Good day, Crime Talk aficionados. We have a great show for you today. First, Abraham Lincoln once said, "A man who represents himself has a fool for a client." Lori Vallow says, "Hold my beer." The physical evidence, or the lack thereof, takes center stage at the Delphi murder trial. Sarah Boone crashes and burns. Jury says guilty. Is Alec Murdaugh innocent? Does the new Murdaugh property owner have something to prove it? We have some videos of some courtroom decorum, this day in legal history, and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and you can check us out on any of your favorite podcasting apps. Now, before we get to the show, yes, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can do as many background searches as you desire, and you can literally get a report emailed to you within minutes of finding a person's name that you want to do a background check on. And when you get that background report, you're going to get information regarding their address histories, possible associates, jobs, education, social media usernames, social media accounts that they have, possible photos, assets, criminal history, whether they have bankruptcies, liens, or judgments against them, ladies and gentlemen. Everything that you're going to find out about somebody that they may not want to tell you when they are starting to come into your life. So you need to check them out and go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for October 28th, 2024. And first on the docket, Lori Vallow. That's right. She wants to represent herself. And as I said, he who represents themselves has a fool for a client. Ladies and gentlemen, I always tell everybody, if you are going to go to court, I don't care what it is for, get yourself an attorney. How do you know if you're doing a good job? How do you know if it's a good deal? How do you know if the prosecution can prove the case against you? Well, Lori Vallow says, I don't care. She wants to do it herself. So Lori Vallow, if you don't know or not familiar with the case, is currently in Arizona, Maricopa County, awaiting trial for the murder of her fourth husband, Charles Vallow, as well as waiting to stand trial for the attempted murder of her niece's ex-husband, Brandon Boudreaux. Now, things didn't go so great for Lori Vallow in Idaho, where she was convicted and ultimately sentenced to life in prison without the possibility of parole for the murders of her youngest two children, Tylee Ryan and J.J. Vallow, and her fifth husband, wife, Tammy Daybell. Now, Chad Daybell, the husband number 5, was sentenced to death for the murders of his first wife, Tammy, and Lori Vallow's two youngest, J.J. and Tylee. So, you know, she's having a little bit of success. Not really. So now she's waiting. So, like I said, the big thing in Idaho not only was the trial and she was convicted, but do you recall that Lori Vallow was deemed incompetent to proceed for 10 months? It took 10 months to restore her back to competency. Well, now Lori Vallow has had her attorneys there ask for a Rule 11 evaluation there in Arizona. It's basically a competency, all right? And apparently Lori Vallow didn't like it because on October 25th, just last week, the court received a motion to ask the public defenders to withdraw on Lori Vallow's case. Now, it also states that Vallow requested to waive her right to counsel and represent herself. And according to the filing, the judge is going to wait on that request until the conclusion of the Rule 11 or the competency process down there in Arizona. So as you may also recall, and if you've been following the channel, the judge granted Lori Vallow's defense team's request for a competency evaluation, and therefore, pursuant to the statute down there, 2 mental health experts will have to evaluate Lori Vallow before her trial can move forward. Now, let me give you a little bit of free legal advice here, ladies and gentlemen. When you're a pro se defendant, it usually doesn't go well. Now, sure, you'll always hear the anecdotal story about the one person that went in there pro se, running the allegation of running a stop sign or a speeding ticket or something along those lines, okay? But when you're talking about murder cases, I don't think I can recall a case, and I'm sure somebody will correct me if I'm wrong, where somebody's won on a pro se homicide case. I'm sure it's happened. I just don't think it happens very often. And why do things usually not go well for pro se defendants? Well, first of all, we don't let people that have gone to law school and passed the bar exam just go do a murder case on their own without any trial experience. But something about going to a jail, there's something about a jail and a law library that is amazing, ladies and gentlemen. It's been said that a jail is the holiest place on earth because everybody finds religion. Well, it's also some of the smartest places on earth, because if somebody goes in there and they go into the law library, and that's how it's pronounced, everybody calls it the law library, at the jail, usually people that did not excel in their educational studies can go to the law library and all of a sudden they know everything about the law. It is amazing. It is amazing. Practicing attorneys that specialize in a particular area of law are always constantly trying to keep up on changes in it. But yet somebody with 2 hours of access to the law library, where you can't even print out a case in its entirety because they don't have enough paper for it, suddenly is an expert, okay? And when people think they're an expert, they're going to fail, right? I mean, maybe you can be an expert, but the reality is you're probably not if you're going to be your first time trying to represent yourself in a case, okay? Now, when you get there to the court, first of all, the judge is let the defendant know at this point that I have to treat you like a licensed attorney. I can't help you. I can't help you get exhibits in. I can't answer legal questions. You are on your own. And that usually doesn't go well because most people don't understand the rules of evidence. And so you look silly in front of the jury. And then the jury starts thinking that you're wasting time and that you're simply playing games. And you just don't know what you're doing. You look like a fool. Like I said, the judge can't help you in any way, and you're held to the same legal standards as a licensed attorney. And like I said, a lot of jurors are going to think that you must have just basically given up, that there is no hope, and so you figure you might as well be the captain of the ship as it goes down. And also, when you're your own attorney, guess what? You waive any right to claim ineffective assistance to counsel down the road because you are your own attorney. So, maybe Lori Vallow is not competent or crazy, but maybe she's just crazy like a fox. Let's think about this. She has always been adamant about her speedy trial. Hell, it got her death penalty charges taken off the table in Idaho. Lori Vallow knows what she's doing here. I mean, Vallow, like I said, has moved to continue the case, Vallow's attorneys have moved to continue the case a couple of times, citing the large amount of discovery. Heck, who knows this case better than Lori Vallow? She knows the facts. Hell, she was there. She knows what she did or didn't do. And sometimes attorneys, frankly, have this fear of going to trial fast, like they're going to miss something, and then they're going to get convicted, and then they're going to have ineffective assistance of counsel issues. The reality of it is, in my experience, I think every murder trial that I've won, like walk somebody out, no lesser included offenses, we went on the first trial setting. Why, you say? Because the government, ladies and gentlemen, is like a big old steamroller. You know, the kind where they put that hot asphalt down when the little guy sits up there. And it's a little slow, right? You ever seen one of those steamrollers get going? It's a little slow. You just don't hit the pedal and it just races off. No, it's a little slow getting going. But once that thing is going, it also doesn't stop very easily. And you don't want to stand in front of it once it does get going. So you got to be ready. Don't let the government get off track. So maybe Lori Vallow is a 4D chess genius here. And if she would just get these damn attorneys out of the way, she could get these things resolved. I don't know. Let me know in the comments. Is she incompetent or crazy like a fox? Let me know. Next, the Delphi murder cases. Well, the DNA evidence, or the lack thereof, has taken center stage at the murder trial. And the state's expert testifying that she didn't find any DNA from Richard Allen on any of the items recovered at the murder scene. Not an even little scintilla of evidence of DNA at that scene where somebody was apparently slicing and dicing and choking people and all that. Not a single little drop of DNA. What are the odds? All right, for those who aren't familiar, Richard Allen, the defendant, faces 4 counts of murder in connection with the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge there in Delphi, Indiana. Now, Allen has been in custody waiting trial since his arrest back in October of 2022. Now, during the trial late last week, the Indiana State Police Lieutenant Jerry Holloman took the stand to discuss his initial interview with Mr. Allen. Now, Holloman said Allen became increasingly agitated and couldn't explain how his cartridge, the gun cartridge, from the Indiana State Police firearm expert matched to his gun and just happened to end up at the crime scene. Anyway, Holloman admitted there were mistakes made during the Delphi murder investigation, but he believes that only one person was responsible for killing the girls. Well, of course he does, because otherwise it would look like they didn't get everybody. That would be a mistake, now wouldn't it? And then we got testimony from Stacy Bozoniski. She is an Indiana State Police forensic scientist who testified. And Ms. Bozoniski spent the first part of her testimony outlining her qualifications and giving the jury a crash course on DNA collection and how it's analyzed and interpreted. Then Bozoniski worked on the DNA evidence in the Delphi case and did a report back in March of 2017. It included an analysis of the rape kits administered on both girls. And then the lab tech Bozoniski said that the kits were tested and no semen was detected. Other swabs detected the possible presence of male DNA, but the amount of the DNA was insufficient for testing. However, Bozoniski didn't do a confirming test before she wanted to make the most of the sample. So no male DNA was present on the vaginal cervix swabs, and she told the court that, and she also did find male DNA in the genital swabs and fingernails, but said that that was not necessarily an unusual result. It could have come from shared clothing or yield just a very small amount of DNA. There was no DNA evidence showing the girls had been sexually assaulted, the expert testified to. Now, the expert did go on and say that they found hair in Abby Williams' hand. Now, a key point the defense brought up in their opening statement appears to be from one of Libby German's family members. Testing performed in 2024, earlier this month apparently, showed that the hair came from Kelsey German Siebert, Libby's sister. Now, she soon discussed the cartridge found at the murder scene, and the state's firearms expert, Melissa Oberg, said she turned the cartridge over for DNA testing and fingerprint analysis before they did a lot of their ballistic analysis and data. So Bozoniski said she attempted to collect skin cells from the cartridge. She also displayed the cartridge to the jury for the first time, and she said it was difficult to get DNA from cartridges because of their small size. The DNA found on the cartridge was insufficient for any further analysis. I'm going to call BS on that, ladies and gentlemen. Bullets in gun cases are tested all the time. So are the magazines. And why is there a good chance that if a round is recovered? Now, I granted this one is out in the open. The elements could deteriorate the DNA. But when you're putting that round into the magazine, you're pushing on it quite hard. And that's why they always test for DNA analysis. They know it's there. It's just a question of whether they're going to find it, or is it going to be great enough quantities that they can actually use that. Anyway, the expert added that the state police crime lab no longer tested cartridges because of the difficulty in capturing results. Well, the labs that I'm familiar with still keep testing cartridges. They do. Anyway, other attempts to find DNA from items recovered from the murder scene found most of the material came from one or both of the girls. Now, some hair found on one of the girls' shoes was not consistent with human hair, and nothing, the expert said during her testimony, tied DNA evidence to Mr. Allen or any other individual. Amazing, isn't it? We know these girls were stabbed, moved, possibly dressed and switched in other clothing. Very odd. And yet not a single DNA, not a single thing. Very odd to me, ladies and gentlemen. Very odd. Anyway, the expert, Miss Bozaniski, testified about additional items found at the crime scene, including items of clothing belonging to the victims, and the DNA matched Abby, Libby, or a mixture of the two. Some swabs returned hair consistent with animal hair, and blood pooled around Libby German was her own, apparently, as was blood found on the ground and trees. Blood found around Abby Williams was also her own. And items pulled from the Deer Creek, including socks, a screen scarf, underwear, a tank top, a Nike shoe, a tie-dye shirt, among several items, were also analyzed. And the expert believes that the creek affected the results, adding that the water had the potential to remove or dilute the DNA. She's not wrong there. Now, one item included Abby's profile as a partial sample, although Bozaniski couldn't make the determination on the partial sample. Some items didn't include enough DNA for analysis. Now, Bozaniski said she found no male blood or semen, and she was unable to develop a DNA profile for a potential suspect. Now, swabs taken from the Libby's phone were also inconclusive, and when the lab did get a profile match, results were entered into the CODIS system. That's to see if somebody who's been previously convicted of a felony conviction, they take their blood sample, it goes into the government computer, and they can test that DNA sample to other people that have already had their DNA identified through that testing. So when the lab did get a profile match, results were entered into the CODIS system. That is the database of previously convicted people that have been had their DNA collected or sampled because of a felony conviction, and then they use that for a comparison. Now, obviously not everybody's in the CODIS system because you don't have a felony conviction and had your DNA taken. Anyway, those results, in the end, the result matched a lab employee. This issue led to a communication about proper personal protective equipment at a crime scene. Oh, what that means is, ladies and gentlemen, there was contamination in the DNA testing process, okay? Dealt with this personally myself. Case, how dare you question the DNA? How dare you question it? And then they look at it and find, oh, it's the lab personnel's DNA, which means they didn't follow proper procedures and protocols in the testing process. Anyway, some further analysis was performed at the Indiana State Police post on tree branches found near the girls' bodies, and several swabs were tested for skin cells, with some branches measuring about 7 feet long. 2 of the samples matched Libby. Now, the state sent a set of hairs to the FBI, and the FBI identified 3 hairs not consistent with either girls. No additional testing was performed at that point, and the expert said it was because she hoped newer technology down the road would provide answers. Given that analysis often destroys or compromises the original material, the lab decided to delay the further testing. Interesting. I understand technology is what it is now. You think you'd want to try to use it or wait 20 years, but what if you've convicted the wrong guy? Anyway, when asked about the touch DNA on the branches, Ms. Bozaniski said a casual touch doesn't always leave DNA behind. She also said wearing gloves could prevent such a transfer. Now, she did tell the court she didn't find Allen's DNA on any of the items that she analyzed, and she was unable to develop a male profile suitable for comparison. So not a whole lot of DNA forensic evidence in this particular case. You know, prosecutors love corroboration. They really, really do love corroboration. We believe this guy did it. We've got DNA at the scene. Here, they don't have any physical evidence other than this bullet that was found at the scene, coming from the gun that they say was found at his house. So what do you need? Oh, he confesses. Well, that's going to be their corroboration. We'll have to see what weight the jury's going to give to those statements when they hear all about it. Next, Sarah Boone crashes and burns. The jury found her guilty. Ladies and gentlemen, just think, we all waited 4 years and 9 attorneys later to get this. That's right, a jury reached a verdict of guilty in the second-degree murder trial of Sarah Boone. Now, the jury arrived at the decision after a short period of deliberations that began Friday evening, followed by closing arguments. Prosecutors say that Miss Boone zipped George Torres inside a suitcase during a drunken game of hide and seek, hitting him with a bat and then leaving him inside the suitcase overnight until he died of asphyxiation. Now, the state argued that Miss Boone killed Mr. Torres with malicious intent and to punish him. The defense argued that their relationship was abusive at the hands of Mr. Torres, and that Miss Boone suffered from battered spousal syndrome. Now, the jury was shown a video of the previous incidents between Boone and Torres in which police were called due to alleged violations of no contact orders between the two. This was also one of the first times that Mr. Torres' perspective had been shown. Now, at the center of the case were two separate videos recorded, which are about 11 minutes apart, on Sarah Boone's cell phone of Mr. Torres inside the suitcase, calling out her name repeatedly and telling her that he couldn't breathe. Now, she's just in shock, was the defense attorney's argument in an impromptu news conference outside the courthouse. We're obviously very disappointed, the attorney said. We did the best that we could. It's time that we had to prepare, because obviously it was, only been on the case for about a month. And Sarah really liked the team, and we all got along. I'm glad they were all able to get along. Anyway, the attorneys thanked the jury and praised the work of the prosecutors like they always do. I get it. Anyway, they also said this was a horrific homicide. Nobody really should have to endure this type of struggle and fight for their lives and have to die alone, begging for their last breath inside of a suitcase. I agree, that's kind of terrible. Anyway, justice was brought by the conviction of Sarah Boone, the prosecutors say. Now, this case has a long and arduous history. Sarah Boone rejected a plea deal in which a judge would have sentenced her to 15 years in the prison for manslaughter. A sentencing hearing in her case is now set for December 2nd. Now, the verdict comes after 4 years of delay. Pre-trial hearings, a lot of the delays were a result of Miss Boone going through multiple attorneys. Like I said, the attorney on her case now was number 9. So let's go back. February 24th of 2020, about 1:01 p.m., Sarah Boone calls 911 to report that her boyfriend, Jorge Torres, was dead inside the apartment there in Winter Park, Florida. She told 911 that she and Torres were playing a game of hide and seek the night before, and during the game, both jokingly thought it would be funny, funny, if Mr. Torres got inside the suitcase. Well, Boone said that she and Torres were drinking wine, and it's obvious from the video that she was drunk. And at some point, she went upstairs and passed out in her bed. And she said she woke up hours later to her cell phone ringing, went downstairs and found Torres unresponsive and not breathing inside the suitcase. Minutes after the 911 call, the fire department arrives and says that Torres is dead. Now, the cell phone videos, it's literally on there. And what I'm going to do, ladies and gentlemen, is put this video at the end of the video. So after I sign off, we'll put the video. It could be, some people would say, there's nothing graphic about it, but you know that there's a guy in there. So we'll put it at the end. So if you don't want to watch it, you don't have to. And if you do, you can. Anyway, on the video, Torres is saying, "Sarah, I can't breathe, babe." And during the investigation, detectives found 2 videos on Sarah's iPhone, and the videos appear to show Torres zipped inside the suitcase, occasionally moving and literally begging Sarah to let him out. In the video, Boone repeatedly taunts him. "Sarah, I can't breathe, babe," you can hear Torres. "That's on you," Boone responds. "Sarah, I can't breathe." "That's on you." And then Ms. Boone laughs. Now, according to investigators, those videos were recorded shortly after 11 p.m., and Boone eventually called 911. Now, the second video, according to the records in the suitcase, according to police reports, show the suitcase in a different position, flipped over, and now on the left side of the living room. Now, according to the police reports, the autopsy found that Torres had scratches on his back, a large scratch on his neck, bruising on his shoulder, bruises on his forehead from blunt force trauma. He also had a cut on his lip, according to the autopsy report and testimony. And during the interrogation, she said it was not intentional. Because on February 25th of 2022, Sarah Boone drove to the Orange County Sheriff's Office where she spoke with the detectives for nearly 2 hours. And during that interview, she said that Torres' injuries were from falling off her son's bike and from running into walls. And when the detectives asked her to watch the video found on her cell phone, Boone watched it for a moment and then said she didn't want to watch them. She told detectives that she thought Torres could get out of the suitcase, alleging that it could be unzipped from the inside. However, the detectives questioned that because on the videos, they didn't see Torres' fingers reaching out from the suitcase anywhere. And in the video, you can't see any holes. There's nowhere in there where the zipper separations, you can see a hole. If there's a hole, he's pushing it on it, begging you to get out. We should probably see that hole, one of the detectives asked her during the interrogation. Well, he essentially would have been able to get out, she told another detective. She said, "I didn't zip it all the way. I did not zip it up all the way," she kept repeating. "This is horrific, horrific," she said. "I don't think I'll ever be right because of this," she told the detectives. "It was not intentional. I put my hand on the Bible. It was not intentional. I would not do that to him or anyone," she begged. "But you did," the detective responds. "Well, it wasn't intentional," Boone responds, adding that she thought that Mr. Torres could actually get out of the suitcase. Now, Sarah Boone then went through several court-appointed attorneys before her trial, many of whom asked to be taken off the case due to irreconcilable differences with Miss Boone over her defense. Some exited due to conflicts of interest. Now, irreconcilable differences, basically you just can't get along, always fighting, disagreeing, probably threatening to file grievances. At that point, you're out. Why do you have to put up with that crap? You don't. Anyway, Boone also claimed that her various lawyers were not working with her, not being available, and not having certain evidence that she thought would prove that she wasn't lying in court. Now, one pretrial hearing, Boone submitted a 58-page handwritten letter to the judge with a list of questions, complaints, and critiques regarding how her case was allegedly being mishandled by not only the court system, but her attorneys. At one point, she had to put up an ad, "Inmate seeks attorney." That's what she put up. "Looking for a prosperous challenge? Ready for your close-up on a national television? Are you zealous with a side of keen?" Read the ad. "Show the world who you are with your original, creative, extraordinary expertise, confident ingenuity." Anyway, the trial delayed the motions to dismiss previous attorneys, you name it. It's been delayed. Then COVID-19 in early 2020 disrupted the court system. Many cases, including Boone's, were delayed because there was no in-court proceedings. And then while representing herself, Ms. Boone filed a motion to dismiss her second-degree murder case, citing her constitutional right to a speedy trial. Now, in Florida, the speedy trial means that a person charged with a crime must be brought to trial within 90 days of arrest if the crime is a misdemeanor, or 175 days if the crime is a felony. And it's been more than 4 years since Boone was arrested and charged with murder, she argued. The state of Florida has not met the requirements or proven good cause of delay. And ineffective, substandard state-provided attorneys should have made its request long ago, proving this as a fact. The trial delays in Sarah Boone's cases were caused by several factors. She cited procedural delays of COVID-19, frequent changes in legal counsel, court system backlogs, review and preparation of key evidence, potential mental health evaluations, Boone's rejection of a plea deal, revocation of Boone's right to court-appointed counsel, Ms. Boone's attempt to secure private representation, Hurricane Milton as well, and guess what? The motion was denied. Then in late August, Ms. Boone retained an attorney for her trial that was to begin in October, and Boone argues that she was acting in self-defense. Now, Sarah Boone spoke in her defense, taking the stand during the second-degree murder trial. You can watch that. Didn't go well. We've got all the video up from the entire trial because we brought it to you here on Crime Talk. Now, Ms. Boone said that she lied to investigators when she initially told them her boyfriend had died by accident. Instead, she said she was acting in self-defense. That's what she meant to say. So after Ms. Boone testified and the defense presented their battered spouse defense, it became pretty obvious Sarah Boone should have taken the deal in the case. She is a fool. And literally, you can tell that it wasn't like a just total reckless or even negligent standard, because Miss Boone was taunting Mr. Torres in the suitcase, saying, "That's what it feels like when you cheat on me." I think it would have been better to play, to come in and say, "Yes, I put him in the suitcase, but I was drunk out of my mind, and I just forgot about it. I never intentionally did anything," is what she probably should have argued. But that was Boone's original defense, which lasted 4 years, and then over another 8 attorneys. However, now she said she was a battered spouse acting in self-defense. Like I said, she said on her witness stand, "I lied to the police and basically everyone because I was extremely fearful of being arrested." Now, the battered spouse argument is what's called an affirmative defense. Basically, you're saying, "I did it, but I was justified." Didn't quite turn out that way. A jury said, "Nope, not justified. Anyway, obviously, once the case was submitted to the jury, her fate was in the hands of the jury. And she was originally charged with second-degree murder in the death of Mr. Torres. However, during the charging conference, both parties agreed for the potential lesser-included offenses of manslaughter as well as culpable negligence. The jury also had the option of finding Ms. Boone not guilty of any of the charges, including the lesser non-included charges. But the jury had to be unanimous in their decision, and just before 9 p.m. on Friday, after less than 2 hours of deliberation, they found Ms. Boone guilty of second-degree murder in the death of Jorge Torres. Now, the defense attorney who came on in the end said, hey, we respect the jury's decision. The prosecution had a lot of strong evidence and that they respect that jury's decision. Responding to further questions whether it was Boone's decision not to take a plea deal before trial, he said that the client wanted her day in court. She was convinced in her mind, obviously, that she didn't intend to kill Mr. Torres and that this was just circumstance, because they were both intoxicated. Things happened, that it was really just an unintentional act. And the attorney said, I think she felt bad about any murder conviction or pleading to any type of murder, and that she was somehow criminally responsible for Jorge's death. And I think that was her mindset all along. Everybody knew that. Yes, they did. She was in trial psychosis. She doesn't want to go to court, doesn't want a trial, but doesn't want to plead guilty. And when clients have to get up and say, yeah, I lied to the police in my initial statement, not a good fact, ladies and gentlemen, not a good fact. Anyway, we got to sentencing in a couple of months, and we'll see how it goes for Miss Boone. I think the judge is going to give her the max just because she was so damn difficult. And like I said, the video of the suitcase, we'll put it at the end. Next, is Alec Murdaugh really innocent? And does the owner of the Murdaugh property think he's found something to prove Murdaugh's innocence? That's right. The man who purchased the South Carolina home where Alec Murdaugh was convicted of shooting his wife and son has claimed that he has found new evidence that proves that Alec Murdaugh is innocent. So Alec Blair bought the property of Alec Murdaugh, the estate down there, for $1 million back in February, and decided to do a complete renovation of the house, including an extension of one side of the property. He now says that he has the kennel door and the window that contain bullet holes from the June 2021 shooting, which he claims proves that Alec Murdaugh did not kill his wife, Maggie, and his son, Paul. Now, we all know Alec Murdaugh got 2 life sentences without the possibility of parole for the murders after crime scene experts determined and proved to a jury beyond a reasonable doubt that it was in fact Alec Murdaugh who ambushed Paul in the kennels and then shot him twice before shooting Maggie 5 times, even as she fell to her knees. But the new property owner, who has had the kennel torn down but retained its door. Now, the new owner, who has had the kennel torn down but retained the door, said the placement of the bullet holes suggests that Murdaugh didn't kill him. He says Mr. Murdaugh is too big of a man. He's even bigger back then, and he's too big for the bullets to have gone through in the way that they did, he's arguing. Maybe it was karma for another thing that he did, Blair, the new property owner, said, as it relates to Murdaugh's conviction, but I don't think that he killed Paul and Maggie. Now, he went on to note that many of the locals who lives on the street of the Mosul estate agree with him that the former lawyer is not guilty of the murder, and said that the reason that he bought the estate was because he didn't think Alec Murdaugh did it. He said they also revealed that he has a set of keys and keychains that once belonged to Maggie. He said he's holding on to them in case Murdaugh's surviving son, Buster Murdaugh, would like to have them back. Anyway, following Murdaugh's arrest, his Mosul estate and hunting lodge was purchased by 2 businessmen for $3.9 million. Not going to lie, I wanted it. Just didn't have an extra $3.9 million laying around. Anyway, a few months later, James Eyre and Jeffrey Godley purchased they purchased the property and then chose to carve up the land and put the home and its surrounding 21 acres back on the market for $1.95 million. Now, Godley explained that at the time that he and Ayers had no use for the house itself and were only interested in the land, which they are planning to use for a hunting, farming, and timber harvesting. He noted that they were both locals in the area and they wanted to ensure the home buyer would be a good neighbor. And the new homeowner says that he is a good neighbor and that he lives about a mile away in his own house. The listing at the time suggested that the home could be used as a family residence or a compound, and the site also has equestrian pursuits, potential hobby farm or weekend retreat destination, and it has an airstrip on it, ladies and gentlemen. I'm not going to lie, I wanted that property. I wanted it. Anyway, Blair, the new property owner, is a father of two, now plans to use the house as a second residence, and he owns a hunting cabin just 20 minutes away from the family estate. That's what I need. I need a hunting property, or I can go be a cowboy in South Carolina. Anyway, the man explained that he wanted to ensure that any other homes in the area added to the property were close enough to the house so that his family can move between the two without disrupting his kids' lives too much. Now, he said he has hopes that he's going to carry on out that the residence will remove the bad stigma that surrounds it. Noted that he wants to change the home's narrative in a positive way. Now, if I had bought that property, I wouldn't have cared if I had been murdered on that property. It is gorgeous property in South Carolina, okay? Seriously. Ugh. Anyway, maybe someday we'll still get that because, South Carolina is my adopted second home. Anyway, we'll see how things go down there on the property. I'm not sure that the door is going to prove anything because, as I seem to recall, that argument was made in court and it was rejected by the jury. So I'm not sure how this is going to change much of anything. Next on the docket, let's talk courtroom decorum. That's right, a convicted murderer was seen lunging at the father of a teen he killed over a pair of sneakers. Adrian Crosby was found guilty on Friday and sentenced to life in prison in Florida for fatally shooting Andrea Camps Lacayo. She was 18 years old back in 2020 during a violent shoe exchange. That's right, a shoe exchange, ladies and gentlemen. So as the young woman's father, Alex Camps, addressed his daughter's killer, well, he did refer to him as an animal and a monster during his victim impact statement that he was allowed to make. Mr. Crosby cursed at the man and suddenly jumped towards him. Several sheriff deputies restrained Mr. Camps before dragging him out of the courtroom, while the slain girl's family also had to be held back from the murderer. "You are the epitome of evil and darkness in this world," the father told Mr. Crosby. "There's only one place animals like you belong, and that's in prison for the rest of your life." The court today confirmed once again that the truth that we were all seeking was that you are a fool, a liar, and a monster, and what you did not only to Andrea but to our whole entire family and friends. Mr. Crosby then angrily responded, "What the F you talking about, biatch?" as he stood up, lunging towards his victim's grieving family. Nice guy. But hey, what have you got to lose when you're going to prison for the rest of your life without the possibility of parole? I guess you're going to go for it. Anyway, a quick background. On April 7th, 2020, Camps Lacayo and her boyfriend, Sergio Bergen, were supposed to exchange with George Walton as they hoped to sell a $935 pair of Adidas sneakers launched by the rapper Kanye West. Well, the couple were trying to make extra money during the COVID-19 pandemic. They met Mr. Walton outside an abandoned home in Homestead, Florida. Walton asked the young couple if he could try the expensive shoes on, but Bergen insisted that he should show proof of payment first, according to the police reports. Crosby then approached Bergen's vehicle on the driver's side and opened fire on him and his high school sweetheart. Camps Lacayo was shot at least once in her torso, while Bergen was grazed in the arm by a bullet. Now, Bergen then frantically drove off, pulling over to the side of the road, where he realized that his girlfriend was in fact dying. By the time first responders arrived, they found Camps Lacayo fading in and out of consciousness. Well, the pair was rushed to the hospital, and Camps Lacayo died in surgery. Both Walton and Crosby were arrested in connection to her murder. Now, even though Walton didn't fire the gun, he was convicted of first-degree murder and attempted murder, complicity. A judge also sentenced him to life without the possibility of parole over a pair of sneakers. And I don't know if I've ever seen a pair of sneakers. I know things are only worth what people are willing to pay for them, but I've never seen a pair of sneakers worth $935. Really. They would have to let me run a marathon in record time for me to pay $935 for a pair of sneakers. Next on the docket, this day in legal history. On October 28, 1886, President Grover Cleveland officially dedicated the Statue of Liberty. Now, although not a legal event in and of itself, the statue became obviously an enduring symbol of freedom, immigration, and civil liberties. Its dedication marked a historical moment tied to the principles of liberty and justice for all, which obviously shaped U.S. law here in the United States. And then on October 28, 1919, Congress passed the Volstead Act, officially enforcing prohibition after overriding President Woodrow Wilson's veto. The act prohibited the production, sale, and transport of alcoholic beverages, leading to the significant legal and social changes in the United States. Remember, prohibition lasted until 1933, when the 21st Amendment had to be passed to repeal it. Got to make it the right, ladies and gentlemen, a right to drink. And as a criminal defense attorney, hey, sex, drugs, and alcohol, that's why we're here, ladies and gentlemen. And if there weren't alcohol sales, there probably would be a heck of a lot less crime, and I probably wouldn't live the life that I live. Thank you, 23rd Amendment, I guess. I say that jokingly, ladies and gentlemen, jokingly. I don't even drink, for goodness sakes, because I realize it's not good for you. It makes you do stupid things. It clouds your judgment. It's not healthy for you, but we digress. Then again, on October 28th, 1968, President Lyndon Baines Johnson signed the Gun Control Act into law. This law was passed following the assassination of Martin Luther King Jr. and Robert F. Kennedy. And what did it do? It established regulations on firearms sales, ownership, and manufacturing. That's why you have to be able to literally trace a firearm from the time it comes into the country or is manufactured into the country to where it goes after it's out of the manufacturing facility to the store that it goes to who buys it. Of course, it doesn't matter when, if they're stolen. And clearly, being able to track firearms hasn't really helped a whole lot in gun control. But that's an argument for another day. Anyway, finally today, our dumb criminal of the day. A Leesburg, Florida woman was arrested for theft after leaving a Walmart with a cart containing over $1,100 worth of merchandise. What did she have in there? A lot of Monster energy drinks and Twizzlers. So officers were dispatched to the Walmart about 9:41 a.m. on October 19th. The call was about a woman by the name of Shaylee Casey who pushed a shopping cart full of merchandise out the door, passing past the sale points and just simply walking out the front door onto the property. Well, once the police arrived, they met with the asset protection employees, and they stated that about 9:30 a.m. They observed a woman in a black hoodie, a pink undershirt, a bonnet, and some black leggings walk out of the Walmart with the shopping cart full of unpaid merchandise. The report said that the suspect, later identified as Casey, left through the general merchandise door. That's code for the front door, ladies and gentlemen. Bold, I say. Anyway, Miss Casey could be seen crossing the highway with the shopping cart, and the employees advised that she was unsure at what time all the items were in the shopping cart, but was able to identify at least 8 Monster drinks worth about $17, 3 bags of Twizzlers worth about $7.75, and the Walmart shopping cart value $742.56, bringing the grand total to $767.26. Who knew the shopping cart was worth $742? Anyway, the report said they could not verify the other items that were in the stolen shopping cart. But once the officers left the store, they checked the area in the general vicinity where Miss Casey was allegedly walking, and they saw on the video cameras. Anyway, when they made contact with her, they found the full cart of merchandise. Now, the police report says that they also found a Miss Casey wearing the same clothes from the video footage about 30 feet away from the shopping cart. So obviously it's not hers. She is not possessing it, right? No, it's within your dominion and control at that point, and you left the store with it with the intent to permanently deprive. That's theft, ladies and gentlemen. Anyway, Miss Casey was obviously arrested, placed in handcuffs, and they returned the shopping cart to Walmart. I want to know, did they walk the shopping cart across the highway, or did they put it in the police car and take it over there? After all, that's worth $760. My God, who wants that kind of responsibility? Anyway, the asset protection employees from Walmart then did what they do. They inventoried the shopping cart, found 52 items in there worth another $416.59 for a total of all of the 64 stolen items, a total of $1,159.15. That's right, ladies and gentlemen. That's felony stuff. Anyway, the police reports also note that the criminal history revealed that Miss Casey only has one prior conviction for theft back in December of 2023. It's a gateway crime, ladies and gentlemen. See, you get more of what you tolerate. Had she been caught, prosecuted, maybe they would have deterred this crime. Just maybe. Anyway, Miss Casey's facing charges of grand theft. That's right, grand theft, $750 in value, but less than $5,000. She was transported to the Lake County Jail, where bond is set at $2,500. Needless to say, she is still in custody, ladies and gentlemen. Probably one of the reasons why she was stealing the shopping cart full of shopping goods. Anyway, that's all we have for you today. Thanks for watching. Yes, the video of Miss Boone taunting the man in the suitcase, Mr. Torres. It'll be played after this. Thanks for watching. Remember, the Constitution matters.
Vallow.
For everything you've done to me.
Vallow.
For everything you've done to me.
Vallow.
Fuck you.
Vallow.
Fuck you.
Vallow.
Stupid.
Vallow.
That's my name. Don't wear it out.
Vallow. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Vallow. 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 Vallow, I can't breathe, babe.
That's on you.
Vallow, I can't breathe.
That's on you.
Vallow.
Real or ransom. Might want to give it for it extra. Because I got this.
Vallow.
Real or ransom.
Vallow. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah.
Fuck you.
Fucking breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Shh.